Hello friends, hold up. Because what Aubrey Drake Graham just filed in a New York appeals courtroom is blindsiding his own fanbase in real time, and nobody on the timeline is even reading it. The man from Toronto didn't celebrate the 2-year anniversary of the biggest L in modern rap. He ambushed himself instead. With paperwork his own lawyers begged him not to make public. This is bigger than anyone realized, and your jaw is about to hit the floor when you see what's buried in the docket. And Drake really thought this appeal was gonna resurrect his career? Bro just signed the sequel to his own defeat, in permanent ink on federal letterhead. Before we dive deep into this madness, smash that like button right now, hit subscribe and turn on notifications because trust me, you do not want to miss what's coming next. This one's about to break the internet. Let's get into it. Drake, Aubrey Drake Graham himself, has officially filed a Drake appeal against Universal Music Group over Kendrick Lamar's Not Like Us defamation dismissal, doubling down after Judge Vargas torched his original lawsuit. The appeal landed in the Second Circuit in early 2026, per Music Business Worldwide reporting, with UMG's rebuttal following in March. And Drake really thought pushing this to a higher court was the flex move? Bruh, all you did was give the culture another 12 months to watch you lose in slow motion. Now let's crack open the actual receipts, and what's in that paperwork is wild. Alright family, let's go straight to the quote bank, because Drake's own legal team put words on the record that his diehards are gonna hate hearing broken down. According to Music Business Worldwide's coverage of the January 2025 filing, Drake's attorneys framed Not Like Us as a track that reportedly branded the artist as a criminal pedophile. Their exact framing in the complaint paraphrased. They argued UMG published the record knowing the accusations were, in their words, false and dangerous. When I first read that filing I was like, wait, you're really about to go on federal record calling a rap diss dangerous publishing? Bro said what? That's the dumbest legal flex I've heard in years. You just told the whole world you couldn't answer a song, so you're asking a judge to answer it for you. Then in October 2025, Judge Vargas dropped her dismissal ruling, and per Billboard's breakdown of the decision, she essentially concluded that the lyrics were non-actionable opinion within the framework of a rap battle. Her ruling reportedly stated that any reasonable listener understands diss records are hyperbolic performance, not literal reporting. When I heard how surgically she took the case apart, I had to do a triple take. She didn't just dismiss it. She basically wrote a legal textbook chapter titled, Why You Can't Sue Somebody for Out-Rapping You. That's when you know Drake doesn't have real advisors. It's just yes men and delusion in that OVO conference room. Fast forward to January 2026, Drake's team files their opening appellate brief. Per Music Business Worldwide's reporting on the appeal, his lawyers argued that Judge Vargas created a dangerous rule for the rap genre by giving diss tracks blanket protection. Paraphrasing the brief, they claimed the ruling would allow labels to weaponize art against their own artists without consequence. Nah bruh, when I saw that argument I had to rewind 3 times. You're now telling the appeals court that the entire genre's tradition of diss records is a dangerous rule? You just insulted every rapper who ever picked up a mic. That line right there? That's where he lost every ounce of credibility he had left with the culture. Then in March 2026, per Musical.ly's coverage, UMG fired back with their response brief. Their attorneys reportedly framed Drake's appeal as an attempt to invent a brand new legal standard that would let any celebrity sue over any diss they didn't like. They pointed out that Drake himself, the same artist, has released records taking shots at other artists for over a decade. When I read that clapback I was cackling. UMG basically said, Your Honor, this man is asking you to ban the exact art form that made him rich. Bro woke up and chose violence against his own catalog. This dude really thought this was a mic drop moment. Bruh, you just handed the label a highlight reel of your own diss verses. And then there's the Spotify class action angle. Per Deadline and Complex, a separate lawsuit alleging Spotify artificially inflated Not Like Us streams got dismissed in late 2025 too. The judge reportedly found the allegations of bot manipulation were speculative. No smoking gun evidence produced. When I saw that second dismissal I said nah, this is different. That's 2 federal courts in the same calendar year telling this man his theory of the case is fantasy. Bro really tried to sue the streaming economy that made him. Nah, you can't say that publicly and still expect people to respect your business acumen. It's over. Now that we've got the receipts on record, let's connect the dots nobody else is connecting. Here's where it gets interesting family, because the timing of every single move Drake's team has made tells its own story. And it's a story that makes the OVO camp look allergic to strategy. Look at the sequencing. Not Like Us drops May 4, 2024. The pop-out concert happens June 10, 2024. Kendrick performs the record 5 times in one night at the Kia Forum. GNX drops in late November 2024. And Drake files his UMG defamation suit on January 15, 2025. Exactly 1 month before the Grammys and less than 4 weeks before Super Bowl 59. Here's what nobody's asking. Why would you file a defamation suit in the exact window when the song you're suing over is about to have its biggest cultural moments? That timing? Amateur hour. It's like walking into a burning building holding a can of gasoline. Remember that Grammy sweep? Happened 3 weeks after the lawsuit filing. Record of the Year, Song of the Year and more, per the Recording Academy's own coverage and Pitchfork's reporting on the ceremony. The pattern here is crazy once you see it. Drake essentially handed the Recording Academy a talking point on a silver platter. Every voter in that room knew there was an active federal case, and they still voted the way they voted. That's not accidental. That's the industry sending a message that no lawsuit was gonna scare them off of honoring the song. So Drake really did this 3 weeks before the biggest music award night on the planet? That's amateur hour timing, bruh. The Super Bowl 59 halftime show happened February 9, 2025, less than a month after the filing. Per every major outlet's reporting, Kendrick performed Not Like Us on the biggest live TV stage in America. That means the lawsuit was active while the NFL, Apple Music, and the Recording Academy all publicly endorsed the record within the same 30-day window. This connects to something way bigger. The entire mainstream entertainment industrial complex effectively voted no confidence in Drake's legal theory before any judge even ruled on it. Then the industry insider layer, behind-the-scenes context nobody's connecting. Drake's Universal Music deal is one of the biggest artist label contracts in the modern era. That's public knowledge across trade publications. So when he sued UMG, he wasn't suing a distant corporation, he was suing his own paycheck source. The label he's fighting is the label that has cut checks for OVO for over a decade. That's the hidden business dynamic Judge Vargas basically referenced in her ruling. The idea that a major label would deliberately sabotage its own flagship earner made zero economic sense. Drake really thought nobody would connect these dots? We're smarter than that. You don't sue your own bank and then complain when your bank fires back. And then there's the Yale angle nobody's talking about. The Media Freedom and Information Access Clinic at Yale Law School reportedly filed friend of the court commentary during the case's public record phase, per legal industry reporting. When the legal academy starts publicly siding against you in a defamation case, that's when you know your argument is broken at the foundation. That's not a hip-hop opinion. That's constitutional law scholars looking at your filing and treating it as a teaching example of what not to do. But here's where it gets even more insane, the details nobody else caught. Now check this out. Nobody's talking about the specific language choices inside the appeal brief itself, and the wording reveals more than the argument does. Zoom into the phrase dangerous rule. The exact framing Drake's lawyers reportedly use per music business worldwide. That two-word combo is doing heavy lifting. Think about what dangerous implies in a legal brief. It's emotional language, not technical language. Appellate briefs are supposed to sound cold, precedent-driven, mechanical. When your lawyers reach for a word like dangerous, what they're really doing is begging the appeals court to feel something, because the actual legal argument isn't strong enough to stand on its own. This means the brief is essentially an emotional plea dressed up in a suit and tie. And this changes everything because it tells you the OVO legal team already knows the law isn't on their side. They're swinging for the fences on feelings. And Drake really didn't catch how transparent that reads. That's embarrassing on a whole new level. Now zoom into a different fragment, the framing that UMG allegedly weaponized the record against Drake. That specific word, weaponized, is a tell. Here's what that actually means. Drake's team is trying to reframe a promotional strategy as an act of aggression. But every artist on Universal's roster gets promotional pushes. That's the job of the label. So by calling it weaponizing, they're essentially arguing that any successful marketing of a diss record is corporate warfare. That's a legal argument that would collapse the entire music industry if a court accepted it. That's the problem with this OVO strategy. It can't survive contact with its own logic. Now check the filing timing as forensic evidence. Drake's opening appellate brief reportedly went in during January 2026, the same month that historically marks Grammy nomination season and the pre-Grammy media cycle. Coincidence? Nah. This is the second time Drake has strategically dropped a legal filing in Grammy season. First time was January 2025. Second time is January 2026. That's a pattern. And what does the pattern reveal? It reveals that the lawsuits are being timed for media impact, not for legal advantage. Because from a pure litigation standpoint, filing during the busiest news cycle of the music industry year makes zero sense. Your filing gets buried under Grammy coverage. Unless the goal was never really the courtroom, If Drake had half a functioning legal instinct, he would have caught this before signing off on the timing. And here's the deepest forensic layer. Look at what the appeal doesn't contain. Per the reporting from Music Business Worldwide, the appeal brief reportedly did not introduce dramatic new evidence of malice. It leaned largely on re-arguing what Judge Vargas already rejected. When an appeal doesn't bring fresh ammunition, that's a huge tell for legal analysts. That's the paperwork equivalent of running the same play that got you sacked on the previous down. And Drake didn't even notice that his own brief was recycling losing arguments? Nah bruh, that's the problem with this OVO. They can't read between the lines because they're still reading the first line of the ruling that already buried them. Alright, let's look at how the different outlets framed this whole situation, because the framing gap tells you everything about where the culture is on this. Billboard framed the October 2025 dismissal in fairly neutral industry standard language, reporting the ruling as a sided entirely with UMG moment and emphasizing the legal reasoning. Their interpretation stayed clinical, but the headline energy signaled that this was a decisive corporate win for the label, not a technicality. That framing matters because Billboard is arguably the most institutionally cautious outlet in music journalism, and even they couldn't dress this up as a mixed result. Now flip to Music Business Worldwide. They went a different direction. Their coverage of both the dismissal and the subsequent appeal has been the most detailed in the entire industry press. They're the ones who actually broke down the dangerous rule language in the appeal brief and covered UMG's response in depth. Their framing has consistently treated the appeal as a long-shot legal maneuver with serious industry implications, essentially positioning it as a case worth watching not because it might succeed, but because of what its failure will formalize as precedent. Then you had Deadline and Complex covering the related Spotify class action dismissal, reporting that a federal judge tossed the parallel case alleging Spotify inflated Not Like Us streams. Their framing was harsher, essentially treating that second dismissal as evidence that the entire theory of a coordinated conspiracy against Drake was collapsing across multiple courtrooms simultaneously. And then there's the counter-narrative. Some OVO-aligned commentators and Drake supporters are still out here saying the appeal has legs and the culture is being unfair to a guy who's just defending his name. Here's why that argument crumbles on contact. You cannot simultaneously argue the culture is being unfair, and the federal court got it wrong, and the streaming platforms are rigged, and the label betrayed me. At some point the common denominator in all those claims becomes obvious. Some Drake fans are stretching to defend the indefensible. Those are the same people who told us the Meet the Grahams response was coming any day now. For 6 months straight, Drake is now fighting the entire modern architecture of hip-hop culture itself, and every institution in that architecture has already voted against him. Think about who Drake is actually up against right now, if you actually map the opposition. He's not fighting a rapper. He's fighting the Recording Academy, who gave Not Like Us its biggest honors. He's fighting the NFL and Apple Music, who greenlit the Super Bowl performance. He's fighting Universal Music Group, his own label parent, in federal court. He's fighting Spotify in a separate class action, arguing his own streaming platform is against him. He's fighting the Second Circuit Appeals Court now. He's fighting the Yale Law School clinic that reportedly commented on the case. And he's fighting the entire critical class that gave his Iceman album a 4.8 out of 10 in Pitchfork's review, per their published critique, a rating that essentially communicates, this album is not going to save your cultural position. Drake is a puppet at this point, and the industry is watching him tie the strings to himself in slow motion. Here's the industry politics angle that connects it all. Labels don't care who wins beefs. Labels care about earnings statements, and UMG's earnings statements have been great during the Not Like Us era, because Kendrick and Drake are both inside their corporate umbrella at different points. So when Drake sues UMG, he's essentially asking a federal judge to punish a corporation for the crime of making money off a hit song. That is not a legal theory. That is a tantrum in a legal wrapper. Every serious industry insider knows this. The industry needs Drake to accept the loss quietly, and he's delivering that public unraveling on a silver platter. Now here's the deep analysis. Why is Drake actually doing this? Because the alternative is admitting the loss in silence. Silence is the one thing Drake's brand cannot survive. His entire post-2015 career has been built on the illusion of untouchable commercial dominance. Not Like Us didn't just make him lose a beef. It exposed the fact that his cultural power was always more fragile than his streaming numbers suggested. And the lawsuit is a psychological pressure valve. It lets his fanbase believe there's still a fight happening. It lets the OVO camp keep marketing his brand as under attack, rather than in decline. It's not a legal strategy. It's a narrative life support machine. Drake is playing checkers while Kendrick's team is playing 4D chess. And every move Drake makes was predicted weeks ago by the same podcast class that used to hype him up. Remember those receipts we walked through in the primary evidence? Here's the real reason those quotes matter. They're not there to win the case. They're there to keep the case alive. Because as long as the case is alive, Drake gets to control the narrative that he's a fighter. The second the case dies for good, the entire framing collapses. That timeline pattern we broke down, the January filings during Grammy season, that's actually about staying visible during the exact weeks the culture is honoring the guy who beat him. It's a psychological survival move disguised as litigation. This is opposition rewriting history because his real story, that he lost a rap battle to a smaller, less commercial artist and hasn't recovered, is too damaging to sell. So he's manufacturing a new story where he's a legal underdog fighting the system. And the mask is slipping in real time. Here's the historical pattern nobody's naming. This is the same playbook the industry has watched with faded stars for decades. When commercial dominance starts slipping, and the artist can't accept it, they reach for the courts. It happened in different forms with legacy artists across the industry going back to the 90s. And every single time, the courts don't reverse the cultural verdict. They just document it for the historical record. Drake is repeating the same mistakes that ended careers before him. He didn't study the tape. We've seen this movie before. Spoiler alert. Drake doesn't survive the third act unless he stops filming it in a courtroom. The social media warfare angle amplifies it further, because in 2026, the meme economy is running the culture faster than any label press release. Every filing Drake's team drops gets memed within minutes. TikTok has essentially turned each new legal document into a comedy asset. Gen Z listeners are experiencing the Drake-Kendrick saga primarily through short-form video clips that overwhelmingly frame Drake as the guy who sued because he lost. That framing is canonizing in real time. And once a meme framing hardens, no amount of legal victory can dislodge it. Drake represents the old guard the culture has already moved past. Follow the money angle, the true kicker. Every day this appeal drags on, Drake's legal fees climb. Every day OVO's business team has to explain to potential brand partners why their headline artist is a plaintiff in a federal defamation case. That is a reputational cost that shows up on every endorsement deal, every sync licensing negotiation, every tour sponsorship conversation for the next 5 years. The industry needs Drake to fail publicly so it can move on, and he's granting them that permission with every court filing. And that's the truth they'll never put on the front page. So the real question is, what happens next? Buckle up because it's about to get wild. Alright family, let's project forward because the next 12 to 18 months are going to be brutal for the OVO camp, and I want you to see the 3 scenarios that are most likely to unfold. Most likely outcome. Here's what's most likely to unfold. The Second Circuit Appeals Court is going to review the arguments and, based on how appeals courts typically handle cases where the trial-level ruling was as decisive as Judge Vargas's, they're gonna affirm the dismissal. When that ruling drops, probably sometime in the back half of 2026 or into early 2027, Drake is gonna be in an impossible spot. Because at that point, he's exhausted his appeals inside the Second Circuit. The next step would be asking the Supreme Court to hear it, and every serious legal analyst will tell you the Supreme Court isn't going to take a rap defamation case that 2 lower courts already resolved cleanly. When Kendrick doesn't even respond to the affirmed dismissal, Drake is gonna look desperate screaming into a void that has already moved on. The silence from the Compton camp is gonna damage OVO more than any diss track ever could. That's when the appeal narrative officially dies, and the fanbase has to reckon with the fact that the legal fight was never winnable. Alternative path. Now, if the appeals court somehow sends the case back down for further proceedings, which would be a legal surprise but not impossible, Drake is gonna face a much scarier problem. He's gonna have to survive discovery. That means depositions. That means his own communications with his team going into the public record. That means his marketing strategies, his social media playbooks, his internal reactions to not like us all becoming potentially subpoenable material. If Drake does get his day in court on the merits, he's getting cooked beyond recognition because the discovery process is gonna surface things his brand cannot survive being made public. We saw what Kendrick's team did to him on Wax with no discovery tools. Imagine what a legal team armed with subpoena power is gonna extract if this case ever gets to actual trial. Drake is not ready for what's coming if this case somehow revives. He'd essentially be reopening the wound he's spent 18 months trying to bandage. Industry impact. Looking at the bigger picture, this case is going to become a landmark reference point for the entire music industry regardless of how it ends. Music law professors are going to cite this case in classrooms for the next generation. Every future rap beef that ever reaches a courtroom will be measured against the Not Like Us precedent. The genre itself is going to have new legal protection because of this ruling, protection that Drake unintentionally created by pushing the case this far. This is gonna be the moment everyone remembers, as when Drake's cultural relevance officially died. 5 years from now, this will be the case study of how not to move as a legacy artist. Every young rapper who ever considers suing over a diss is gonna get shown Drake's file first. And they're gonna choose the microphone instead. Drake is watching the culture move on without him, and there's nothing he can do to stop the precedent that has now solidified against him. Meanwhile, Kendrick's legacy elevation continues. Pulitzer, 5 Grammys for one song in the 2025 cycle, including Record of the Year and Song of the Year, Super Bowl halftime, undisputed cultural verdict. That legacy is cemented. His camp doesn't have to lift a finger. The record itself, the ruling itself, the appeal itself, they're all working overtime for him for free. Whatever unfolds from here, one thing is crystal clear. Drake already lost this war. He just doesn't know it yet. And every filing his lawyers submit just carves the date of the loss deeper into the historical record. Alright friends, that's the full breakdown. The truth nobody else had the guts to tell you. If this exposed something you didn't know, do me one favor. Smash that like button so this video reaches every real hip-hop fan out there. Hit subscribe right now and ring that notification bell, because the next story we're dropping is even crazier, and you do not want to miss it. Drop a comment below telling me whose side you're on. I read every single one. And if you want more truth bombs like this, click on one of these videos on your screen right now. Trust me, you're gonna want to see what we uncovered next. Peace.